The morning they came for my house, I was already awake. I had been awake since 4, sitting in the kitchen with a cup of coffee I barely touched, watching the sky turn from black to gray through the window above the sink. 63 years I had lived in that house. My father built it with his own hands on a half-acre lot in Clearwater, Florida, back when this neighborhood was still dirt roads and citrus groves. I was born in the back bedroom. My wife, Carol, took her last breath in that same room, 22 years after we moved in together. Every scratch on the doorframe where we measured our kids' heights, every creak in the third stair, every water stain on the ceiling of the sunroom from the hurricane of '04. That house was not a property to me. It was the entire record of my life. So when the black sedan pulled up to the curb at 6:47 in the morning and a man in a county uniform stepped out holding a manila envelope, I already knew something was very wrong. I just did not yet know how wrong. I set down my coffee. I walked to the front door. I opened it before he even reached the porch steps. He was young, maybe 30, with a crew cut and the slightly uncomfortable expression of a man who does not enjoy this particular part of his job. He looked up at me and said, "Sir, are you Mr. Harold Briggs?" "I am," I said. He held out the envelope. "I'm Deputy Tillman with the Pinellas County Sheriff's Office. I've been directed to serve you with this notice. It's a court-ordered eviction, sir. The property at this address has been transferred, and the new legal owner is requesting vacant possession within 30 days. I did not take the envelope right away. I stood there in my slippers and my old flannel robe, 64 years old. A retired civil engineer who had spent 31 years designing the water infrastructure for half the municipalities in this state. And I looked at this young deputy and I said, "May I ask who the new legal owner is?" He shifted his weight. "The deed was transferred to a Mr. and Mrs. Derek Calloway, sir." My son-in-law's name, Derek Calloway. I took the envelope, and that is when I heard it laughter from across the street. I looked up, and there was Derek, standing on the sidewalk in front of the Hendersons' yard in a golf shirt and khaki shorts, at not quite 7 in the morning. His phone raised, like he was filming. His wife, my daughter, my Renee, stood 2 steps behind him, arms crossed, not laughing but not looking away either. Derek cupped his hands around his mouth and called out, loud enough for the whole street to hear, "Enjoy the coffee, old man. Last one in my house." I looked at him for a long moment. Then I looked at the deputy. The deputy looked mortified. I said, "Thank you, son. Would you like to come inside while I review these?" He blinked. "Sir, it's early. I have fresh coffee." He declined, politely. I nodded, stepped back inside, and closed the door. Let me back up, because none of this made sense without the 18 months that came before it. My daughter Renee is my youngest. I have 2 sons, my eldest, Paul, lives in Atlanta and works in hospital administration. My middle son, Greg, is a high school football coach in Tennessee. Renee was the one who stayed close. She grew up in Clearwater, went to USF in Tampa, and when she was 26, she brought home a man named Derek Calloway, who sold commercial real estate and had very white teeth and a handshake that always felt like a performance. I tried to like Derek. Carol had liked him, or at least she said she did, which with Carol was not always the same thing. But he was charming when he needed to be, and Renee loved him, and so I gave him the benefit of every doubt I had. They married in 2019. 2 years later, Carol passed, and something shifted after the funeral. I think Derek had always seen me primarily as an asset. While Carol was alive, there was a woman in that house who would have noticed things, who would have said something. Carol had a way of watching people that made them uncomfortable when they were not being straight. But after she was gone, I was alone, and I think Derek began running calculations. It started small. He began calling more often, stopping by, taking an interest in my situation. Did I have a financial advisor? Had I thought about what would happen to the house? Was I keeping up with the property taxes? Reasonable questions from a son-in-law, you might think. I thought so too at first. Then, in the spring of 2022, Derek suggested I consider giving him power of attorney. Just for convenience, he said. "You're getting older, Harold. What if something happens to you? Renee and I just want to make sure we can take care of things if you can't." I told him I would think about it. I did not think about it. I changed the subject whenever he raised it. 4 months later, he stopped raising it. I should have wondered why. What I know now, because it came out in the proceedings, is that Derek had found a notary, a man named Vic Salter, who had a side business that did not appear in any professional directory, and together they manufactured a power of attorney document bearing what was supposed to be my signature. Then, using that fraudulent POA, Derek executed a warranty deed transferring the property from my name into a joint LLC he had created with Renee. Then, using the LLC, he took out a home equity line of credit against my house for $240,000. He had been living in my house without my knowledge for almost a year on paper. I just did not know it yet. I found out the same way I found out most things in those years from my neighbor Roy Hutchins, a retired postal worker who had lived across the street for 30 years and who considered it his personal civic duty to know everything that happened on our block. Roy called me one Thursday afternoon while I was visiting Paul in Atlanta and said, "Harold, you got a surveyor out here this morning. Walking the whole lot. You selling?" I said, "I'm not selling anything, Roy." There was a pause. Well, they had county paperwork. I came home the next day. It took me 2 weeks and a records request to the county property appraiser's office to understand what had happened. When I saw the deed with my supposed signature on it, I sat at my kitchen table for a very long time. Then I picked up the phone and called a man I had not spoken to in almost 4 years, my old colleague and friend, retired Circuit Court Judge Arthur Pemberton, who had served on the Pinellas County bench for 26 years before his retirement. Arthur listened to everything. When I finished, he was quiet for a moment. Then he said, "Harold, don't touch anything. Don't confront anyone, and call Raymond Flores tomorrow morning first thing." Raymond Flores was, at that time, one of the 3 best real estate fraud attorneys in the state of Florida. I called Raymond the next morning. What followed was 14 months of work that I was not allowed to talk about. Not to Derek, not to Renee, not even fully to Paul and Greg, because Raymond was very particular about what I said to whom and when. It was 14 months of quietly gathering the original notarization records from the county, the HELOC documentation from the bank, security camera footage from 2 businesses near Vic Salter's office, phone records obtained through proper legal channels, a handwriting expert, a forensic document examiner who specialized in signature analysis. I will tell you honestly, those 14 months were the hardest of my life, harder even than the years after Carol died, because during that time, I had to continue seeing Derek and Renee at family dinners. I had to sit across from my son-in-law while he poured wine and made jokes, and occasionally gave me a look, not a mean look, just a slightly proprietary look, the look of a man who believes he has already won a game the other player does not know is being played. I had to watch Renee, my daughter, and wonder how much she knew and how much she had simply allowed herself not to know, which are different things, and both of them painful. Raymond told me, "The more normal you act, the better our case." So I acted normal. I ate the dinners. I laughed at the jokes. I asked Derek about the real estate market. Inside, I was building a case that would take his roof off. The court date was set for a Thursday in October. Derek had hired an attorney named Carl Weston, who was aggressive and expensive and apparently did not do enough research on opposing counsel or on me, which became relevant later. The hearing was before a judge named Sandra Okafor, who had been on the civil bench for 11 years and had the focused, impatient energy of someone who has heard every variation of every excuse and is no longer interested in the ones that are not supported by evidence. I sat next to Raymond at the plaintiff's table and watched Carl Weston make his opening argument, which was essentially that I had signed the POA willingly and had forgotten doing so, that I was an elderly man whose memory was not reliable, and that the deed transfer was entirely legitimate. He said elderly man 4 times. Raymond let him finish. Then Raymond stood up, buttoned his jacket, and walked Judge Okafor through 14 months of documentation. The forensic document examiner testified first. She was a 20-year veteran of the Florida Department of Law Enforcement, and she explained, in plain and specific language, 11 separate characteristics of the signature on the POA that did not match my actual signature. Pen pressure, letter formation, the particular way I cross my T's, which I have done the same way since a 3rd-grade teacher made me practice it 200 times. She said the signature was not a bad forgery, it was actually a careful one, but that careful forgeries still leave traces, and these had. Then Raymond called the notary records custodian from the county. The notarization on the POA listed a commission number for Vic Salter. What the records showed was that Vic Salter's notary commission had expired 11 months before the date on the document. An expired notary. The whole thing was void on that basis alone. Carl Weston objected 4 times during that testimony. Judge Okafor sustained none of them. Then Raymond called me. He asked me simple questions. Had I ever met Vic Salter? No. Had I ever signed a power of attorney in favor of Derek Calloway or any entity he controlled? No. Had I been present at any notarization? No. Where had I been on the date the document claimed I had signed it? At my son Paul's house in Atlanta for a long weekend, and Raymond produced the Delta Airlines boarding pass, the hotel receipt, and a signed statement from Paul confirming the dates. I was in Atlanta. I was not in Clearwater. I could not have signed anything here. Carl Weston's cross-examination of me lasted 11 minutes. He asked if I had any reason to want to harm my daughter's marriage. I said I had every reason to want my daughter to be happy, and none to want her married to a man who had committed bank fraud against me. He asked if it was possible I had signed documents I did not remember signing. I said that in my 31 years as a licensed civil engineer responsible for public water systems serving 300,000 people, I had signed a great many documents, and I remembered all of them, because that was what the job required. He asked if I had any professional background that would give me particular familiarity with legal documents and record-keeping. Raymond had told me this question was coming. He had told me to answer it plainly. I said I spent 31 years as a senior civil engineer for the Southwest Florida Water Management District. I was also, for 9 of those years, a licensed title insurance agent in the state of Florida, which required me to understand property transfer documents at a professional level. So yes, Carl Weston paused. He had not known about the title insurance license, he said. No further questions. Judge Okafor did not take long. She found the power of attorney fraudulent and legally void. She found the subsequent deed transfer invalid. She found the home equity line of credit obtained through the fraudulent transfer to constitute bank fraud, and she referred the matter to the state attorney's office. She ordered the property restored to my name. She ordered Derek and Renee to bear all legal costs. When she read the ruling, I kept my eyes on the table in front of me. Raymond put his hand on my arm briefly. I nodded. I did not look at Derek. I did not look at Renee. I did not trust what my face would do. The state attorney's office took the referral seriously. Derek was charged with forgery, fraudulent use of a power of attorney, and bank fraud. Vic Salter, the expired notary, was charged as a co-conspirator. The bank recovered the $240,000 through a civil action against Derek personally, money that, it turned out, he had spent on a boat, a lease on commercial office space, for a real estate venture that had not launched, and several other expenditures that are no longer my concern. Derek pled guilty 8 months later. He received 4 years in a state correctional facility, with eligibility for early release after 30 months. Vic Salter received 2 years. Renee was not charged. The investigation found insufficient evidence that she had participated in or had specific advanced knowledge of the forgery. I do not know how to feel about that finding. I have spent a great deal of time sitting with it, and I have not arrived at a clean answer. What I know is that my daughter made choices about what she allowed herself to see and what questions she did not ask, and that those choices came from somewhere, and part of that somewhere is probably a failure I carry. She called me 6 weeks after Derek's sentencing. We talked for a long time. I will not share what was said because it belongs to us and not to anyone else. I will say only that the conversation was hard and that we are still slowly finding our way back to something. Whether we get all the way there, I do not know. I hope we do. On the morning of the eviction notice, the morning Derek stood across the street with his phone out. Laughing, I sat at my kitchen table and opened the manila envelope and read every page. Then I called Raymond Flores. He answered on the second ring, because I had warned him this morning might come. The court hearing was 3 weeks away. Derek, apparently, had decided to get ahead of it by filing an eviction using the fraudulent deed, betting I would simply fold. Raymond said, "Let him serve it. Don't respond to him directly. I'll have an emergency motion filed before noon." I said, "He's across the street filming right now." Raymond was quiet for a moment. Then he said, "Harold, go back inside, make yourself breakfast, and do not give him anything worth filming." I did exactly that. I made eggs. I made toast. I sat at my father's kitchen table in the house my father built, and I ate my breakfast. And outside, eventually, the black sedan drove away, and Derek and Renee drove away, and the street went quiet again. 3 weeks later, in Judge Okafor's courtroom, it was Derek's composure that broke, not mine. His attorney had told him the case was manageable. He had believed that because he wanted to believe it, and because he had spent long enough being the smartest person in rooms where no one was watching what he was doing. He had made the same mistake people like him always make. He had confused a person's silence for weakness, and a person's age for decline, and he had never once stopped to wonder what was actually behind that silence. What was behind it was 31 years of professional precision, 9 years of title insurance, 14 months of careful preparation, and a phone call made 4 years earlier than Derek ever suspected to a man who had spent 26 years on the bench and knew exactly what justice looked like when it was properly assembled. The morning they came for my house, I was already awake. I had been awake for 14 months. They were not ready for that. They should have been. My name is Harold Briggs. I am 64 years old. I still live in the house my father built, on a half-acre lot in Clearwater, Florida. The key still sticks in the front lock in the summer, the same way it always has. The third stair still creaks. It is still mine.